we would like to take some questions from social media. We've grouped them together just for convenience. There have been questions regarding case backlog, delay in court cases, as well as specific questions about how the court proposes to address the slow pace of trials, particularly mentioning the Maguindanao massacre trial.
Okay. Case backlog. All right. There is no single solution to the congestion of court dockets. The congestion of court dockets, I have found after my initial studies, are concentrated in 4 areas. 4. So please note, these are in all the courts of the National Capital Judicial Region, which is Metro Manila. The second is in the Calabar zone. The third will be in Angeles, and the fourth will be in the Cebu metropolitan area. Okay. So if I am going to be strategic about how I'm going to solve congestion, I have to focus my energy on those 4 areas. So what are we doing at the moment? Right now, we are assigning some of our judges from outside of those areas to help as assisting judges in these heavily congested courts. They are also the priority in the filling up of judicial vacancies. And the JBC chairman of the executive committee is here to attest to that. We are also launching the electronic court system in Quezon City, and we are already starting to identify the next areas for which the electronic court system will be rolled out. And it will be, in all probability, be in the NCR, and they will progressively be rolled out in the most heavily congested areas until there is already a nationwide coverage of the electronic court system. We also have the Justicia Decongestion Program. Now, allow me to describe to you briefly what I launched in Quezon City 2 months ago, Teddy? Or 2 months ago. We had courts which had dockets of more than 500 as our priority courts. And we assigned DCA Raul 8 or 9 teams. The first 8 teams made up of judicial supervisors, volunteer lawyers, and volunteer law students. And I'm thankful for the law schools for sending their law students to help inventory the court dockets, meaning physically inventory, read the entire case files, maybe several rolos for a particular case, and make the major milestones and analyze. And after they have swept through the entire inventory, they come up with a decongestion plan that they discuss with the judges. After they already have the decongestion plan, then they are able to recommend to us whether we need to assign more judges to implement that decongestion plan that the judge assigned to that area already accepts as reasonable and doable. So with that, we hope to be able to clear a lot of the court dockets. And the highest docket that we have inventoried is the docket of Judge Panganiban, correct? Which had 2,200 cases. Okay. So after we analyze that, we are able to have a decongestion plan. Because my theory is this: there can only be a case carrying capacity over which the judge is already inefficient. I am figuring that it will be in the vicinity of 300 to 500 cases. After that, he will no longer have a genuine work-life balance, or he will be inefficient, or there will be injustice along the way. If we can allow the courts to have that smooth case-carrying capacity in all our courts, then naturally, litigation time will be faster. The other, so that's, we have already spoken about assisting judges, the decongestion plan, the electronic court system, which is a case management tool. Although the public is able to enjoy the kiosk because they can already identify the status of their cases and can predict when the next hearing will be. The beauty of the electronic court system is that the judge himself can have a plan to prioritize which cases, because the electronic court system has a way of aging the cases and alerting him about the detention time that prisoners are already serving and whose cases therefore must be expedited. So the judge can be stricter with the prosecutors and the PAOs. Now, one major reason for the delay of criminal litigation is the absence of PAO lawyers and prosecutors. For us to achieve a correct pace in litigation, we have to have a 1:1 balance. In other words, in some areas, you have one prosecutor assigned to 5 courts. And if you have one prosecutor assigned to 5 courts, you can just imagine that a case of a prisoner in detention will most likely be calendared only every 4 or 6 months. We have right now 2,200 lower court judges. We only have about 1,700 to 1,800 prosecutors, that number. So there is a 500 prosecutor gap. On the other hand, I heard that there are only about 1,500 PAO lawyers. So there is a 700 or 800 PAO lawyer gap. There is not a 1-to-1 correspondence. That's why you have hearings getting postponed intolerably. And that cannot be tolerated. And I've already communicated this problem to Secretary De Lima, and I've already mentioned this in a social function to the President. There must be a 1:1 correspondence. Then we have the judicial affidavit rule. When it is in full operation, it will cut down litigation time by 50%, because we have estimated that the presentation of the testimonies of witnesses, the direct testimonies, take up 50% of the litigation time. I had already described to you the agreement that we had with Secretary Rojas, where he will ensure the appearance of police witnesses. We are right now trying to conceptualize. We already, in addition to the podcast in the Supreme Court where you are enjoying the oral arguments, we just distributed more than 2,000 audio recording devices which are pedal activated, which will allow our stenographers to produce stenographic notes faster. And we are trying to look at the rules so that we will be able to make these audio recordings available to the parties so that they can file their pleadings without waiting for the transcripts to be finished. Attorney JJ, you understand how important that is. Nobody waits for the transcripts anymore. If we can do that, but we have to revise some of the rules to allow that. We are already also looking at electronic notices. Just imagine, if you are notified officially by SMS that the calendar for your case is on such and such a date, and you also receive a corresponding notification by email, and we will consider that as conclusive on you, the electronic notification system, we will cut down the 2 months that it takes for the postal registry return card to be given back to the court before the court is satisfied that notice about a particular incident has already been given to the parties. So electronic notification, we are also looking at electronic filing. As you can see in the Supreme Court, when we are ready, we are hoping that pleadings can already be filed electronically before the Supreme Court. We are looking at whether we can set up kiosks in the most populated areas so that lawyers, even those who do not have the technical facilities to do so, can find a way to scan their pleadings and mail it through that electronic kiosk that we are looking at. The problem of the congestion, the problem of prolonged litigation has to be solved by a menu of solutions. Not a single solution is sufficient.